I think that's a good indication. Okay, we have the Senate Election Law and Municipal Affairs Committee. We'll call it to order, and we'll start off with our first hearing. And we have the prime sponsor here to introduce the bill.
Well, good morning, and thank you for having me, Mr. Chair and the Election Law Committee. I don't get over here to testify in this committee very often. For the record, my name is Senator Howard Pearl. I reside in the town of Loudon, and I represent the voters of District 17. I am here today to introduce Senate Bill 287. So we had a very clear directive from the voters last fall that election integrity was important, and that we want to make sure that we're looking at our processes and the way we do, how we handle voting, and make sure we're tightening up those loopholes. In conversations with some of my colleagues, we identified that there's still a potential loophole in our absentee ballot system. So really simply what this bill would do is, if you want an absentee ballot that's mailed to a different address other than yours, that you will provide either a photo ID or a notarized signature that you are who you are and you're asking for this ballot to be mailed to you. That's the basic nuts and bolts of what this bill does. I know the secretary is here, as well as some others that are going to testify on it too. I'm going to leave some of the further details to them. I do have to run back to Exec Committee and Energy. We're in the middle of doing some bills, so but I'll stay as long as you have questions for me. So thank you.
Do the senators have a question? Seeing none, thank you very much.
Thank you very much.
And goodbye. All right. Let's see. Rep. Hill.
Good morning, Mr. Chairman and rest of the colleagues. I am Representative Greg Hill, Chairman of Legislative Administration here in the House. I reside in Northfield and represent Merrimack 2. I'm here to testify on Senate Bill 287. If you'll indulge me in just a minute, I have a little scenario for you. Suppose Senator Pearl walks into his bank and with a deposit slip and finds out that his account has been closed and there is no money in it. After some pointed fingers and screaming, Senator Pearl would be sitting, looking and asking what to do. And the bank may produce a piece of paper that arrived to them by mail that says, I am Senator Pearl, or I am Howard Pearl. I have an account at this bank. Please close the account and send the money to this address in Dayton, Ohio. What does Senator Pearl do? That's essentially what we have with this small slice of absentee ballots in New Hampshire, to my belief. We have a situation where people claim they are someone, or can claim they are someone, ask for the absentee ballot to be mailed to an address other than the address that's on their on the official checklist. The ballot is filled out, sent back in, and at no time does the clerk know for sure that that is Senator Pearl requesting that absentee ballot, or Joe Blow, the garbage man. They have no idea. So you may think that this is speculation. So back in 2019, I think it was 2019, Deputy Scanlon and I asked the people in Concord, the HAVA people, if they would take a look at specifically that subset of ballots and tell us whether there is anything unusual, or were there any ballots that specifically went to common addresses outside New Hampshire. And I have for you the data from that study. Chairman Gray has seen this before, but it, I think, bears repeating for some of the people that perhaps haven't seen this. What the people reported was that in the 2016 election, 14,418 absentee ballots were mailed in this fashion to addresses outside New Hampshire. That means they were mailed to an address without positive identification of who the person doing the requesting was. So the first line of the Harbor report indicated that New Hampshire town clerks mailed 23 ballots to a single unnamed address outside New Hampshire. And I say unnamed because the law stipulates that no one is to know what that address is without a court order, not even at that time Deputy Scanlon. So it went on beyond those 23 ballots being sent to an unnamed address, all the way down, 21 ballots going 2 times to a same physical address, 3 times, 19 ballots went to the same physical address, all the way down, 20 times 5 ballots went to the same physical address, and so on. This does not, I want to be very clear, this does not represent voter fraud or anything of that type. It does, however, I believe, ask for further investigation. It's entirely possible you can explain why some of these have occurred. Someone may live or go to school at Brown University, and all of the ballots were mailed to a central mailing location at Brown University and then distributed to various dorms. That's entirely possible. It's also possible that instead of multiple dorms, it went to one dorm, and one dorm got, 21 ballots. We don't know. So there is another bill to investigate what this is doing. This bill, and actually, I believe the chairman's Bill 213, Senate Bill 213, I think, either in combination or separately, will address this concern. I would like one or the other to be passed. My suggestion in this bill was to simply ask for a copy of the driver's license to be given to the clerk before they mail an absentee ballot to a physical address not of the checklist original address, or have a notarized signature. Senate Bill 213 talks about just writing in the number from the driver's license or something like that in there. I would be happy with either of those. I would be happy with all of those as options for someone to do. So with that, I'm happy to entertain any questions. Again, I want to point out, this is not proof of anything. It's just a data point for you
Questions
to
from
look
the
at.
senators? Senator Rocher.
Yes, thank you, Mr. Chairman. Thank you for coming in. And you may have said this, I may have missed it. What time frame is this information that you provided us? Is this one election? Is this how many years, or is it 1 year?
Thank you for your question. It only represents the statistics from the November 2016 election.
Okay, so just one election.
One election. We did the same thing, I think, for the 2018 election. That's been lost in my computer somewhere. And I don't, to my knowledge, Secretary Scanlon may have a better information. To my knowledge, it has not been repeated. We have not tried to get the information in any other elections.
Thank you.
Sure.
Additional questions? Seeing none, thank you very much.
Thank you.
Secretary Scanlon, you have your choice either now or later.
I'm here to answer questions primarily, Mr. Chair.
All right, so we'll put you later then. All right, going down through the list, Ms. Tantarelli.
Good morning. Thank you. My name is Liz Tentarelli. I'm here representing the League of Women Voters of New Hampshire, a nonpartisan organization. Of course, voting integrity and the ability to vote are part of our mission. I was not aware of Senate Bill 213, and I will now go and look at it. It certainly, yeah. It certainly makes more sense to simply allow somebody to put in the number of a driver's license rather than to require somebody who might be serving in the military or in the government overseas, or even a UOCAVA voter to go and find something that is the equivalent of a notary, or to require photocopying of a driver's license. My friend Janet moved to Ireland about 14 years ago, and she wasn't sure she was going to stay there permanently. So she voted from her home address. And she actually, I was handling a lot of her affairs here, one of which was some financial documents that needed to be notarized. And she said, we don't have notary publics in Ireland. And so I said, well, what do you have? And she said, well, we have and I've totally forgotten the name. She got somebody to authorize her signature, sent those financial documents to me. I processed them. That worked. I'm not sure that getting a notary, the equivalent of a notary from a foreign country is going to mean very much to a supervisor of the checklist. And there are certainly places in the world where getting photocopies of IDs are much more difficult than it is for people here. The very fact that somebody needs to vote absentee means they are removed from some of the services that we take for granted. When my son was in Yemen, I think he would have been able to get his ID copied. He was working in offices there for the federal government. But that would have been necessary, I guess, for him to get a ballot under this circumstance. I do want to address Section 3 briefly, and then there are other people here who can address it more thoroughly. This is the part that says if somebody presents an application without the ID or notarization, then we go to a signature match. And I want to speak on behalf of my friend Joan Ashwell, a league member who testified in this committee for many years before her health prevented that. She has severe arthritis. She testified in 2018 that she could not guarantee her signature would look anything like itself day to day, depending on the arthritis. The court case, and again, people will talk more specifically to this, would say that without training, an average person cannot do a signature match, and with the confidence that would be required to reject a ballot. But I also want to ask this committee to look at the very few cases of voter fraud prosecuted in New Hampshire, and are there any that deal with fraudulent absentee ballots being submitted? There was one case a few years ago where someone submitted an absentee ballot on behalf of their spouse who had recently passed away. That was done out of love. It was wrong. It was misguided, but we could understand why that happened. I don't know that there have been other cases that show 23 ballots coming from some address somewhere else, for instance. And I realize that Representative Hill did not say that it happened. He was pointing to an investigation of a possibility. But why are we trying to fix a problem that has not been identified? So thank you very much for the opportunity to present this point
Questions
of
from the
view.
senators? Senator Spoken.
Yeah, thank you, Ms. Tentarelli, for being here. Could you speak a little bit more to the signature match piece? I think you make your point that it's obviously difficult for some of our voters who might have the need to have a ballot mailed to them at a different address to get those signatures. But do you have a citation for any court rulings about signature match?
It was a 2018 case, and there is somebody here from ACLU who will give you all the details on that, Senator.
Wonderful. Thank
Thank
you, Ms.
you.
Tentarelli.
Thank you.
Okay, seeing no other questions, thank you very much. Open democracy, I guess we've got two of you. No?
Hi,
We only
Mr.
have one?
Oh, I am going to be testifying on behalf of Mandy Merrill. I will summarize hers briefly. So for the record, my name is Kaylee Estradio. I am a Durham Voter and Public Policy Fellow with Open Democracy. We're a nonpartisan nonprofit organization representing 36,000 voters across the state, and I'm submitting testimony today in opposition to SB 287. This introduces an unnecessary and burdensome hurdle to the absentee ballot voting process. Voters are already required to present their birth certificate or passport as proof of citizenship during the registration process. It is a form of governmental overreach to require further proof of identity from voters who choose to request an absentee ballot by mail to an address other than that shown on the official checklist, and assumes that the majority of voters have ill intent in doing so and need policing. This will most impact elderly, disabled, student, and military voters, all who have equally valid reasons for requesting their absentee ballot to addresses other than those who appear on the checklist. Section 1A notes that voters shall be treated as verified if they show the clerk photo ID that meets the requirements of RSA 659-13, Section 2A prior to Election Day. This would require the voter to be physically present in order to vote, which is counterintuitive to the point of mail-in voting as a whole. The other option presented in Section 1B for verification requires a notarized signature on the application form. Finding a notary public is costly and time-consuming and will work to impose burdens on the most vulnerable in our communities, whom the mail-in voting process is intended to aid the most. Failure to provide verification of these types will result in the voter's signature on the absentee application being compared to that on their absentee ballot affidavit in the same manner as other voters, a practice which has been proven in Saucedo v. Gardner from 2018 to have disenfranchised hundreds of absentee voters throughout New Hampshire during past elections. In considering this bill, I urge you to factor in what's more important at this specific point in time: combating the hypothetical threat of voter fraud, or protecting the constitutional rights of our community members. I respectfully ask you to consider voting SB 287 as inexpedient to legislate. And then just briefly from Amanda Merrill, who is a Durham voter and former state senator and member of this committee. She says, "Dear Senator Gray and committee members, I am writing in opposition to SB 287. I noted that the bill has 10 Senate sponsors and frankly was surprised that it has the strength of support presumably reflected in that number. I believe that SB 287 is an unnecessary response to a virtually non-existent problem, i.e. voter fraud. The criteria for designation as a, quote, verified voter described in paragraph 1 would impose an obstructive layer of documentation on prospective voters who, for good reason, need to have their absentee ballots sent to an address different from that listed on the local checklist. Elderly voters who find themselves in a rehab center or hospital come to mind as just one group of citizens likely to be affected by the legislation. Do you really think that all such facilities will provide photocopying and notarization services, as well as proactively advising patients as to their availability? I, for one, do not believe we can count on that level of service from busy healthcare professionals. Let's not add another obstacle to the lives of our older and wiser community members. It is unfortunate that the scheduling of hearings on SB 287 and as well as other election law bills is on our traditional town meeting voting day, and it will preclude many election officials from traveling to Concord to participate fully in the legislative review process. However, I trust you will hear from some of them. Thank you for your consideration, and I hope that you will find SB 287 inexpedient to legislate.
Questions from senators? Senator Perkins Spoken.
Thank you for being here. I just wanted to ask, do you think some of why we don't have local officials, election officials here today is because it's town meeting day?
Yes, I do.
Okay, thank you.
Additional questions? Seeing none. Mr. Perry.
Good morning, Mr. Chairman, members of the committee. I speak in opposition to SB 287. This bill requires applicants for absentee ballots to present a copy of their photo identification with their application if that applicant wishes to have that form mailed to an address other than that shown on the checklist. When 1,500 miles from my polling place, my absentee ballot was mailed seamlessly to an address different from my domicile. I hope you will agree that this is a common necessity to assist those who must travel and those who vacation elsewhere. I'm going to assume very few election workers are handwriting experts whose subjective opinion is worthy of denying the franchise to what would otherwise be a legitimate voter. This bill does not authorize any particular person to compare signatures, leaving it to election workers to seek opinions from others when they are unable to come to their own conclusion. Who in that room will make the final decision? Further, in what I believe to be settled law, the United States District Court for New Hampshire in the matter of Saucedo et al. V. Gardner, a 2018 case, struck down signature matching of absentee ballot applications when compared with the voter's signature on the affidavit. It seems this decision goes to the heart of the bill and renders it unenforceable. Should I be wrong, I will continue with other matters that concern me. Not all voters own a printer or one that is reliable or that prints with sufficient clarity that signatures could be compared for authenticity. The cost to repair my printer very recently was $152 and required a drive to Rochester Staples. Persons without transportation, however, or those confined to elderly housing, or those who cannot justify the expense of maintaining a little-used printer will need to seek other options. Those without access to printers at all, or those who do not have the option to ask friends or family or the person next to them, who may also be disabled, to drive them to the nearest printing service will need to seek other options. Those who do not have the option to ask others to run an errand to photocopy photo identification on their behalf will need to seek other avenues to comply. Those who delay, as most of us do, may well find their right to vote has escaped their capacity to conform to ever-expanding regulations to carry out a fundamental right. This bill is at minimum unnecessary, and I urge ITL.
Questions from the senators? Seeing none, thank you very much, Mr. Perry.
Thank you.
David Trumbull?
Good morning. Thank you, Mr. Chairman and committee members. My name is David Trumbull. I'm from the town of Ware. I would oppose this bill for a few reasons. Before getting to the specific obstacles that this bill creates, I just would like to note in overview that voting is not a privilege. It is a fundamental right, as has been held by the U.S. Supreme Court long ago in the case of Harper versus Virginia. Judge Douglas wrote that the voting is a fundamental political right. The right to exercise the franchise in a free and unimpaired manner is preservative of all other basic civil and political rights. Right now, New Hampshire is number 50th of all 50 states in America, and that's obviously, you all know that, being on this committee from the election journals report. We're the most difficult state to vote in. There's no reason to make it harder to exercise this right. And lastly, just as looking at absentee voting in general, we usually average about 10% in this state, but in 2020, 32% of votes were cast absentee, and there was no indication, no evidence whatsoever from that 1 in 3 votes that there was any voter fraud. As for this specific legislation, look at the two scenarios. You have one is the signature matching. As has been stated, the case of Saucedo versus Gardner, the judge in that case took the evidence that was presented, the testimony of the forensic expert that said they would need 10 signatures in order to make an accurate comparison. And that's somebody who's in the field of signature matching, asking the moderator at a town hall to do that without having 10 signatures to match would be impossible. The judge in that case also held that it was unconstitutional because it specifically affected people who are elderly, people who are disabled, people for whom English is a second language, people who are under stress, and people taking medication. So these are the people who would be disenfranchised. If you don't think elderly and disabled people or people who have English as a second language are worthy of voting, you might vote for this bill. But if you believe that everybody should be entitled to vote, you would vote against this bill. And in that case, also, the judge accepted the testimony that in 2016, 275 people in New Hampshire were disenfranchised because of the signature matching provisions. That's a lot of people in New Hampshire, almost 300 people. As for the other scenario where you can either turn in a photo ID or with a notary public, the photo ID, bringing that photo ID requires an in-person visit to your town clerk. That would be obviously on its face unconstitutional because people have the right to be out of state. Also, people have transportation issues. That's one of the justifiable reasons why you can ask for an absentee ballot, or they could be overseas, either serving their country or going to college. The other option that is offered is the notary public. That also requires transportation because the notary public does not come to your home. This means that you either must make a trip to the town clerk or a trip to the notary public just to access an absentee ballot. Also, notary publics, unless you have a relationship with a bank or something, will require fees. So in essence, that's a poll tax. One last point, and that's this, is that this question about unnamed addresses, it was admitted by that testifier that that could have been Brown University. It could also be an overseas agency that helps people overseas access their absentee ballots, and then they would gather ballots, and then people who are maybe studying abroad in England or whatever. There is no evidence that you have fraud in front of you. No evidence. Why would you make us the 50th state in America, the hardest to vote, even harder when there's no evidence? Also, the bill is overbroad. It would impact people who are these requirements would impact people, as has been noted, in a nursing home, maybe getting rehabilitation for a medical issue. They might be on extended vacation or studying abroad. Those people will be impacted by the requirements you're putting on this bill. Why do we want to make it harder for people to vote? It's not a privilege to vote for the few. It's a right for everybody. Thank you.
Questions from the senators? No, no, no. You understand? Do you understand, sir? Questions from the senators? Okay, thank you very much.
Thank you, Mr. Chairman.
And Henry, since you can't repeat anything, I think you got a hard road.
I drove all the way up here for this. Good morning. My name is Henry Clementovich. I'm the Deputy Legal Director of the American Civil Liberties Union of New Hampshire. I don't want to repeat what others have said, but I did. I just want to talk a little bit about the Cecito versus Gardner case, which our office did in 2018. So in essence, what this bill does is provide that if a person doesn't submit photo identification or a notarized request, then their absentee ballot request is going to be sent through the signature matching process. But I wasn't sure if this committee was aware that signature matching process has been permanently blocked by the federal courts. And so I don't think this bill actually accomplishes anything.
Take exception to the word permanently.
Well, the court issued a permanent injunction, I guess is what I mean.
Permanent injunction, but left the door open for a way to cure and the training of the individuals.
So
Anyway, excuse me for interrupting your testimony if you'd go on.
So the court identified a number of problems with the signature matching scheme in New Hampshire, including lack of uniformity among election officials, lack of training in handwriting analysis, lack of guidance distributed by the Secretary of State's office, lack of opportunities for voters to cure in the event that their signatures were rejected. And this bill does, in my view, nothing to address any of those flaws identified by the court. And so I would expect that the injunction would remain in place. The state had an opportunity to appeal that injunction. It did not. So it's still a valid injunction that can only be lifted by a federal court. And so I think the state would find a high bar trying to remove that injunction under this proposal. I'd also just point out that in addition to the fact that there's been really no evidence presented of absentee ballot fraud in New Hampshire, the scenario identified by another where an unnamed senator goes to vote and finds out that a person has already cast an absentee ballot in his name. We know that that isn't happening because we would know if it was happening. Because if I went to vote and Senator Perkins Quokka had already stolen my vote with an absentee ballot, I would know when I went to the polling place because my name would be checked off and I wouldn't be given a ballot. And we know that isn't happening because people would be saying that that was happening. So I guess in essence, what I'm trying to say is that this is a solution in search of a problem that I don't think would get past the federal court. I'm happy to take any questions about Cecito or otherwise.
Questions from the senators? Seeing none, thank you very much. Mr. Scanlon, you're the last one on the list unless there's somebody on the continued list.
Thank you, Mr. Chairman, members of the committee, Secretary of State David Scanlon. I was going to come just to answer questions, but, I had to reread the bill sitting here after listening to the testimony because, it was contrary to what I think the language in this bill actually does. The title, of course, does say requires applicants for absentee ballots to present a copy of their photo identification with their application. But if you read the bill itself, everything that I see in here is permissive. It applies to a small subset of voters or a subset of voters, those who want their absentee ballot mailed to an address other than the one that is listed on their registration as their residence or domicile. It allows the voter to show their ID if they go to the clerk's office to request an absentee ballot for an upcoming election. Or it allows the voter to get a notarized signature on the application. It doesn't require it. It just creates this opportunity. That opportunity does two things. It gives the voter assurance that when the moderator and the clerk in a town receives their absentee ballot, that it is going to be counted because it's already verified. It also helps the local election officials when they're processing those ballots because they can see that that effort has taken place to verify the qualifications of the voter obtaining that absentee ballot. It goes on to say that if a voter does not choose to do that, the process is still the same as it currently exists. There is language in the statute that requires a signature match. I completely agree that the Saucedo v. Gardner case precludes moderators from actually trying to determine whether the same person signed the application and the affidavit on the envelope, but the moderator is required to reject an absentee ballot if there are two different names on those documents, John Smith versus Tom Doe. The ballot would get rejected in that case, or if there is a signature that is missing on one of those items, the ballot would be rejected in that instance as well. So I will I would like to say that I keep hearing this debunked report from the Northern Illinois University that says that New Hampshire is the hardest state in the country to vote in. That irritates me to no end because it's garbage. New Hampshire is a very easy state to vote in. That is proven by the fact that we have one of the highest voter participation rates anywhere else in the country. The criteria that was used in that study is unfair to the state of New Hampshire because of the way we conduct elections here. And I just want to make it clear that New Hampshire is one of the best places to vote in the entire country. So I'm happy to answer any questions, Mr. Chair.
Questions from senators? Then it's my turn. For people in nursing homes, many of the towns visit the nursing homes and complete both the request and the identity stuff at the nursing home. And I believe that there's another bill in the legislature right now to actually make that more permissive. Is that correct?
That's correct.
Uwakava voters, military voters outside the United States, they have a separate federal list of requirements that would not be affected by this bill, I believe. Is that correct?
That's correct.
And I could go on, but I forgot all of the other ones that they asked. Thank you.
Thank you.
All right. since, go check the list, please. Just make sure there's nobody else on it. Is there anybody here that thinks they want to testify now that didn't sign up? Okay. There were people online that signed up, 16 in support, 179 opposed. All set. Okay, you can bring me the next sheet. And with that, we will close the public hearing. And as soon as the aid is ready, we will open the next one. And sir, just so that you know, there is a code of conduct for Senate meetings that's over there that precludes what you were trying to do as a plot or whatever. So, just so you know.
It's right here.
All right, and we will open the hearing. You can
Sure.
just return that one to this podium.
Hello.
We have a substitute for the prime sponsor.
Yes, I am not Senator Lang. My name is Tricia Malillo, Senate Majority Caucus Director, here to introduce Senate Bill 222 for Senator Lang. This bill moves the primary date, or would move the state primary to the second Tuesday of June. Additionally, it also moves all the election deadlines that are relative to the primary to March, which would be the filing deadline and the registering of your party affiliation, et cetera. And I can take any questions.
Are there any questions? Seeing none, thank you very much.
Thank
Secretary Scanlon, I'm guessing you want to go last again?
Actually, I can go now.
Okay. Secretary.
Thank you, Mr. Chairman, members of the committee. I'm David Scanlon, Secretary of State, and I see there's a very impressive list of sponsors on this piece of legislation. So I may be swimming a little bit against the tide. My preference for moving a primary date would be to a date in August as opposed to all of the way into June. I understand that there are valid arguments for both a June date and an August date. But the concerns I have about moving to June is, number one, the impact on voter turnout. Actually, moving both dates is relatively unknown. Obviously, we want as much voter participation in these elections as possible. I am concerned about compressing the workload on local election officials. If we move it to June, it would result in a filing period in March. That's town meeting season. A lot of things going on with local election officials in towns, not so much cities. And so I'm just concerned about the extra workload in a tight time frame. And then I think moving the primary forward several months would certainly force the discussion of whether the term of governor should be 4 years or not, because the campaign season is going to begin immediately after getting elected if we have such a tight time frame. I will point out a couple of things that if the committee and the legislature does decide to go to a June primary date, I've got some suggested language here for an amendment. I think it's pretty self-explanatory when you read it, but right now there is a provision in statute that says that let me back up. Before the filing period opens, there is the evening before the filing period opens, the supervisors of the checklist are required to be in session so that they can handle voter registrations and changes in party affiliations, because once the filing period opens up, the voter is locked into the party that they are registered in or participating in the primary whenever it occurs. There is also a provision in the statute that says that when the supervisors of the checklist are required to meet multiple times within a 21-day period, that their first meeting will suffice for the meetings that would follow for a 21-day period. The timing of a June primary and the filing period that's listed here would be within that 21-day window of meetings required for town meetings, school district meetings, and things like that. I think it's really important that we make sure that the filing period session is still held so that voters that need to change their party affiliation before the filing period opens up have the appropriate opportunity to do that. So that's what this language in the proposed amendment says. And then the other concern that I have, and this is a policy decision of the legislature, is the third-party nomination process, where a third party that wants to obtain ballot status can start collecting nomination papers after the first of the year. But then the submission date of those nomination papers that have been collected are tied to the date of the state primary election. So when it's in September, they've got 8 months plus to collect the signatures and then submit them. If this process gets moved to June, we cut the ability of those parties and individuals to collect nomination papers by many months, a major percentage of the time that they have. So if a June primary is in the works, that is a process that we'll need taking a look at. With that, I'd be happy to answer any questions.
Questions? For that date, could we simply go in and change the amount of time that they would have until 1st of August, and that would solve that and give them additional time?
Yes, I think that's one way to do it.
The reason I ask that is because anyone who does get all the paperwork that they need and all the signatures they need will go on the ballot, and so there's no elimination by party, which would happen in the primary.
Right.
Question, someone who voted in the primary, would they also be able to sign the nomination papers for a candidate, a third-party candidate?
Yes. Any voter can sign one nomination paper for a candidate for the same office.
Even if they voted in the primary for a Republican or a Democrat?
Yes.
Additional questions? Seeing none, thank you very much,
Thank you.
Mr. Secretary. And Mr. Khan.
Good morning, Mr. Chair and Senators. My name is Kevin Kahn. I'm a resident of Exeter, and I've come to speak to oppose SB 222. Our Secretary of State basically hit the point that I wanted to talk about with third parties. I'm here representing the New Hampshire Classic Liberal Party, and we are affiliated with the National Liberal Party USA. We're a new party. Since the point has been brought up, I won't belabor it as far as how this might affect third-party candidacies, but I would say that a similar type of moving forward of the primaries happened in Ohio in 1983, which was litigated up to the Supreme Court of the United States, Anderson versus Celebrezzi, and in the majority ruling, the SCOTUS said a burden that falls unequally upon independent candidates or on new or small political parties impinges by its very nature on associational choices protected by the First Amendment and discriminates against those candidates and voters whose political preferences lie outside the existing political parties. SCOTUS also noted that removing petitioning candidates so far from current events created a temporal burden as well by saying an early filing date may have a substantial impact on independent-minded voters. In election campaigns, particularly those which are national in scope, the candidates and the issues simply do not remain static over time. We all know that New Hampshire has a very independent-minded voting populace. 41+% of our registered voters actively choose not to affiliate with a party. So we'd like to ask you to consider possibly amending the bill as suggested, tying the petitioning period to the general election instead of the primary elections, or tabling the bill that you can review the multiple RSAs that currently describe the petitioning process for third-party ballot access so they can be reworked. Thank you for your time. I'm happy to take questions.
Questions from the senators? So if you do get certified as a party, you'd go to the primary date, but you are not opposed to changing the date when a third-party candidate needed to submit their papers to, say, August 1st, August 15th.
The longer the better, sure. It's for the federal elections, 4,000 signatures is the burden that independent and third-party candidates need. And the best petitioning time is not during the winter or early spring, so the longer we have in the summertime would be better, sure.
Okay, seeing no additional questions, thank you very much.
Thank you.
Is there anybody else on the new sheet? Online, there was 7 support, 2 opposed. And there's no one else on the sign-up sheet. So we will close that public hearing, and I'll take a motion to go into executive session.
Second.
A motion and a second to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. We are in executive session.
Thank you. Ooh.
Okay.
No way to get that. Oh, look it. You got it. You did it.
Long run. All right. Certainly looking at the last bill that we just heard, that will take an amendment if we're going to incorporate Secretary of States and the change in dates. Anybody want to talk about that before we move on to the others? Okay. 222 is on hold. Want to give you an opportunity to talk about 287. Certainly, we had heard a lot of conversation about getting copies done and other things, which, as far as I know, the Secretary of State takes pictures too. We have Zoom, we have a lot of different things that are out there that allow the people to do this. Certainly one of the things that we talked about last year when we were talking about House Bill 1370 and the amendments that were made to it before it got killed. Thank you for at least recognizing that was humor. Was Zoom and other means of communication. So certainly I'd be interested in probably having a conversation with one of you two about what we can do to do something with that. But
Okay.
I think that we can solve a lot of the people's their apprehension with the bill. I may not be able to get far enough to make, a 5-0 vote, but
Okay.
I think I can get,
I look forward to it, Chair.
okay. All right, so the things that we've got on the back burner, Senate Bill 46. This was the bill that was shoreline protection, and et cetera.
Yes.
There is another bill that Senator Pearl has. I think that this one has problems, and I will move ITL.
I'll second that.
Comments?
I think we discussed, Chair, that this sets a concrete value in statute for certain land, which you know, just probably isn't a very workable system. So while the intent, I'm sure, is good, I look forward to a version that maybe more reflective of reality and flexible.
And we'll hopefully get that. But we'll see what happens. All right, further comments on this bill? Senate Bill 46. All right, the motion is ITL. All those in favor say aye. Aye. All those opposed say nay. The ayes have it.
Now
We
move
have
consent.
Have a motion to go on consent. All those in
Second.
favor say aye.
Aye.
Aye. All those opposed say nay. The ayes have it. And I'll take that one out. Okay, next one I have is 216. We've certainly heard an awful lot of testimony on this bill. Having been a moderator for many years, I think that there's an awful lot that a moderator can do. Can a moderator control the area that's outside, that's not part of the property that they're having the election? And the reason I word it that way is in Rochester, Ward 4 used to vote at the Home Depot. Okay, so Home Depot would clear out a corner, they'd come in, put the voting booths in. Now, how much of that property did the moderator control? Okay, I'm not quite sure, but there was an agreement that seemed to work for quite a number of years. In Alton, we have a church right next to the town hall. And I believe that the parking lot that most of the voters use is actually the church parking lot. Now, I have a lot of problems with the way the moderator in Alton, excuse me, I should say Gilmanton, not Alton. The way the moderator in Gilmanton sets up his electioneering zone and no electioneering zone, but again, when we get to this bill here, the best I could do is re-refer, but I don't think that that's really necessary, so I will move ITL.
Second.
Additional comments?
I will just add to your commentary, Chair, that I know this is an ongoing issue, but it seems that, as you've pointed out, that local folks are able to kind of work it out almost all the time. So I don't think we want to take this authority away from the moderator.
All those in favor say aye.
Aye.
All those opposed, nay. I have a motion for consent.
Okay.
And any further comments? All those in favor of consent say aye.
Aye.
All those opposed say nay. And RPK,
Sure.
put you down for this one. And 224. This one goes in and does one of them, and that's a problem. I really have not had the time to actually sit down and do what I think would have to happen to this bill to fix it. There's the regular veterans credit, there's the all veterans credit, there is the disabled veterans credit. When we look at who testified on this bill, Senator Rochford looked at the report and give us a little synopsis of what it says.
Yeah, it was, we had the prime sponsor and DRA. So there was not a veterans group that testified on this, on this.
And with that, I guess I would make a motion that we would ITL this one also. Is there a second? There is no second.
I'll second that.
Okay. Comment.
Thank you, Mr. Chair. Yeah, I mean, I look at this as the 750 goes to 1,000. I called my district, City of Manchester, which they do offer both. We're in the city, we're only maxed out at 500. So I'm looking to bring that up if this were to go through. And they offer both. They offer the 500 that Manchester does instead of the 750, and also 2,000 for the disabled vets. Those are the only two that the city of Manchester uses. So I wasn't at issue with this. Just increasing from 750 to 1,000.
Certainly it would take an act of the governing body to do this. I believe the governing body.
Yeah.
But I think I am a veteran, okay? And both here and in Rochester, when I was on the city council, I did not vote for these very often. Okay, and the reason being, in my opinion, the ones that really need it are the disabled veterans, especially the 100% disabled veterans. And I think it is significant that no towns came and testified, no veterans group came and testified, and when asked questions about this bill and how it affects the various people getting the benefit of the veterans credit, that leads me to the place that this probably is not the right thing to do, especially in the lieu of that there's a lot of towns out there that are going to have very tough budgets this year. State's going to have a tough budget. And the more I divert that money, the taxes I do not collect from a veteran, then somebody else has to pay for it. So, further discussion.
You make the point I was going to make, Chair, which is that obviously we want to support our veterans. We want them to be able to stay in place, and also tax credits always have the unfortunate consequence of driving up housing costs on our families and other sort of working class folks. So they are a balance. And I hear your points. I do see in the testimony from the DRA that none of these credits are stacking, so you can either select the standard tax credit, the optional tax credit, or if neither of those, instead you are eligible for and select tax credit or service connected disability. So I think your comment, unsurprisingly, is astute in that, if we're going to change one, we really should be addressing all of them together. So I understand your point. Thank you.
Seeing no other comments, all those in favor of ITL say aye. Aye. All those opposed?
I'll oppose.
Okay. 3-1. And do you object to consent?
I don't.
All right.
Consent?
All those in favor of, okay. You can make the motion, I'll second it for the record. All those in favor of consent, say aye.
Aye.
All those opposed? And that's a 4-0. And I'll take that one out too. Okay, the only other thing that I've got in my folder are the 2 re-referred bills. That square with everybody else?
Yep.
Yeah.
Okay. Do I have a motion to come out of executive session?
So moved.
Second?
I have a motion and a second to come out of executive session. All those in favor say aye. Aye. All those opposed say nay. Our business today being complete, we are adjourned.